Okay, I think we're live. Hello, everybody.
Hi, everybody. Welcome to the first Facebook Live where nobody with the last name Joseph or Hall is on here. The bosses are away, so we can say literally whatever we want and hope that they don't watch this and get in trouble for it. I don't know how to do banners, so I don't think we're going to do banners today.
Oh, a banner. I thought you said banter.
We'll try our best on banter, but again, don't ding us if that's not up to the normal standards. Yeah, I don't know how to do banners, so we'll just talk and ramble on for a little bit.
Sure.
We each have a couple of things we want to talk about, and then we'll get to questions and go from there.
Yeah. So I think I'll start off with I was looking for stories to talk about for today, and I found that Yemen has been redesignated for temporary protected status. So if you aren't aware of what that is, it's if a country goes through a natural disaster or a war breaks out or something like that happens while people from that country are inside of the United States, they can be designated for temporary protected status, which is a protection from removal. It in and of itself is not a pathway to citizenship, but it at least means that you cannot be deported because your home country is going through this turmoil. So Yemen had already had temporary protected status, but it has been extended as well as redesignated for temporary protected status. And what that means is that if you have been in the United States since 2021, and you have been here up until now, then you can now apply for temporary protected status as a Yemeni citizen. And that will be, you can do that, you can register until March 3rd of 2023. So you have quite a long registration period there where you can go and sign up for this potential status or temporary protected status. I also wanted to touch on how the Department of State has announced automatic extensions for national interest exceptions. So as I'm sure many of our viewers are already aware, there are many presidential proclamations in effect because of COVID, which have said, hey, if you're from these areas and you've been there for the past 14 days, you're not allowed in except for specific groups of people. And one group of people, which was a broad category, could get a national interest exception. And those people were people that provided vital support or executive direction for significant economic activity in the United States. So people making a lot of money in the United States and that the United States economy depends on to be in the United States, they could get an NIE. Journalists, people with extraordinary humanitarian circumstances, and people that supported national security or public health. And those are a lot of nurses and medical workers. So they could apply for an NIE. And the Department of State just announced that all NIEs that had been issued in the past 12 months will now be extended up to 12 months from their issuance. So no matter how long they had been issued for, they are now good for 1 year from the date of the issuance. So it's not from now, but it's from their original date of issuance. And they're now good for multiple entries as well. So if you had an NIE, and it was maybe going to expire at some point soon, but just know that it might have been automatically extended, and you should check the Department of State's notice on this extension to see if that applies to you.
All right, is it me now?
Yeah, I think so.
Well, here's the banter now. I realize that every time Rylan and I are on one of these together, we dress very similar. I guess it's just our Facebook Live outfits that we wear. He's much more well-ironed than I am, but regardless. Anyways, so what I was originally going to talk about is employer compliance and I-9s, which are super relevant for a lot of really anybody who works in the United States, but perhaps are not super exciting to just hear about. But an hour and a half ago, got an email in my inbox that the Attorney General has essentially gotten rid of this case called Matter of Castro Tum, which, for those of you who are not aware, that case, it stated basically that in immigration court, immigration judges are not able to use this procedure called administrative closure to essentially take cases off their docket that don't have, I guess, pending relief, or there's potentially other avenues for these folks to take. It was a huge mess. It's caused people to basically have to keep going back to court over and over and over when they really should have their case closed as they're proceeding through perhaps a marriage-based petition through USCIS. There's a lot of things that you can't do if you're in removal proceedings. Where your case is administratively closed, you are able to do them. Probably the most important one being a provisional waiver of unlawful presence. So let's say that you came to the United States without authorization, you entered without inspection, but now you're married to a U.S. citizen, and you're basically able to go and get a green card, so long as you're able to apply for this waiver of your unlawful presence. Once you have over a year of unlawful presence, as soon as you depart the United States, you're barred from returning for 10 years. So it's a big deal if you're not able to apply for these waivers. But with this decision from, I think it was Jeff Sessions who did that one, he said basically, immigration judges don't have the authority to manage their own dockets and don't have the ability to take cases out of the queue. They have to continually hear over and over these cases and request continuances and grant continuances, and it was just a big mess. So it's real good news for everybody that this has been overturned and that administrative closure is back. And it's only an hour and a half old, so I guess I'm not quite sure how not really implemented in practice, but it's huge news. Going to be life-changing for thousands and thousands of people. And it's going to be huge for the courts themselves. Studies have shown that administrative closure, while it was asserted, were contributing to growing backlogs. It was actually a way that backlogs were being reduced. So, by giving judges the ability to prioritize certain cases over others, judges are able to actually get through cases rather than having to hear yet another "can we have more time" type hearing. So very big for that, and beyond that, I mean, it just helps judges kind of manage what they're working on. We don't have to constantly hear requests to postpone court dates because of whatever reason it may be. Now you can just have your case administratively closed, and if the government wants to bring you back into court, they can do so. It's just it's a great way to move forward. I did that super fast, so I'm still going to talk about employer compliance. Sorry, everybody. It's not exciting, but it's really important. Basically, when you go and you start a job at any U.S. employer, you have to fill out a form called an I-9. Anybody who has worked recently for an employer knows, it's the part where you bring your driver's license and your social security card or your passport, and it shows basically that you have, you are who you say you are, and that you're authorized to work. Sometimes, though, people will provide false documents. Sometimes employers will hire folks who are not authorized to work, and in those situations, ICE comes by and they audit those employers' I-9s, and they determine if there have been any unauthorized workers in those employment, those places of employment. Where they have found those violations, they can levy fines, and those fines can be pretty significant. I mean, it could really be about $2,500 to $3,000 per violation, and they'll try to ding you several times per I-9 if you don't know what you're doing. So it's really important for places to do a good job of putting their I-9s together. And where these I-9 audits do happen, it creates this real long process that culminates in a hearing before the Office of the Chief Administrative Hearing Officer, or OCAHO, as it's nicely called. We don't usually get to OCAHO because normally you'll settle the case before then and say, okay, I won't pay $1 million, but I'll pay $500,000 based off of all these factors. the factors that are considered by statute are not necessarily what have to be considered by the court, by OCOHO. So that's where the negotiations and the lawyering comes into play, and you start to, I guess, fight about things like ability to pay, for example. You know, it's the middle of COVID. How could I pay $1 million fine? Let's reduce it. Because the whole point of an I-9 audit and fines associated with them, it's not to be punitive. It's not to be a punishment. It's supposed to be educational, and a way to make sure that employers don't violate I-9 regulations again. But getting to the case that I wanted to talk about, I think it's called Psychosomatic Solutions. Psychosomatic Fitness, sorry, is a recent case that came out from OCOHO, and it's one of the more recent cases about I-9 audits. They have been kind of quiet about them for quite some time. So cool to hear some new law coming out, but the result's not exactly what we want to hear. Biggest thing being that where before the size of a business was not something that the Office of Chief Administrative Hearing Officer would feel limited to, I suppose. There are these, statutory factors as to what can increase a fine and what can mitigate a fine. One of them being the size of a business, and those are only plus or minus 5% of the total fine. So it's not exactly a massive amount of change you'll get in your fines if the government decides that you're a small business versus a large business. Others being like a history of compliance, for example, is another one that can be an aggravating factor or a mitigating factor. But historically, when you would go to OCOHO, they would say, okay, well, there's a governmental policy of leniency towards small businesses where we're going to give greater than 5% mitigating fine amounts, mitigating percentages, just because this is a small business, and perhaps the small business doesn't have a dedicated HR department with somebody who is well trained in I-9s. So it's been a really strong push for us to use when we're negotiating down I-9 fines. But this case came out, and essentially the court there said, hey, because the size of a business is specifically in statute as one of the aggravating or mitigating factors, we're no longer going to use it as this kind of overall and discretionary way to mitigate fines. So it's been one of the big ways that I've negotiated down fines in the past, is saying, hey, this is an employer of 15 people, of 50 people, of however small the business may be, and make those exact arguments about perhaps the sophistication of the HR department and the level of training that that department has just by virtue of the size of the business. It's been a huge push that I've made, and it's been very successful, and it's now no longer going to be successful. You have to find new ways to make these pushes, new negotiations, negotiation tactics to use, and that sucks. Not a good case, but I guess that's where we're at with the employer compliance world. I find I-9 audits to be just horrible. There are businesses that really do abuse undocumented folks and pay less than the minimum wage and really just take advantage of their immigration status. But in my experience, those are not the places that are getting audited. It's the small business. It's the immigrant-owned company that the person just really didn't know how to fill out the I-9, and as a result, they're getting hit with these educational fines of thousands and thousands of dollars. So I don't like I-9s, but I like working on them just because I think it's an area of law that's just horribly unfair.
Yeah, and it sounds like it's with this decision, it's even worse, and that's so frustrating because we were just talking about this yesterday. How they don't appear to be going after the big fish that are making that know what they're doing and are exploiting people, and instead they're going after people that just aren't intentionally doing anything and can't afford such large fines. That's really frustrating.
I mean, I've seen in the past where companies have even had other like HR auditing companies come in and help them with their I-9s and try to make corrections as best they can. But then ICE will come in shortly after and audit them. And even though they've done everything they could to correct the errors that they made originally, they are still hit with there's massive fines. Like they're trying their best. I mean, good faith is another one of those statutory factors that can be aggravating or mitigating. But again, if you do your best, you act in as good a faith as you can act. That's still at best a 5% mitigation of your total fines, which when you get to be in the tens of thousands, the hundreds of thousands. I mean, I've heard of cases of millions of dollars before. It's 5% is pennies, not literally pennies. It's a lot of money there, but still, it's not going to really be the determining factor of whether your ability to pay this massive fine is there or not. Anyways, I see there's no questions on that. I explained it very well, and you all are experts in I-9s, and I've sparked an interest, I'm sure, for everybody in complying with employment authorization requirements. So I suppose you're welcome.
I need to learn from you on how to talk about topics for much longer than I already have.
The secret is to ramble, and it's like Michael Scott says, you just start a sentence and you see where you end up at the end.
Okay, should we go into some questions?
Questions. There's not a lot. I see.
There's not.
Yeah, let's do what we can.
Okay, so we have a question from Catherine, and I see that we have multiple questions about the Penn case. And Jennifer, she's the attorney in charge of the Penn case, and she is on vacation. Good for her. Very happy for her. She really deserves it. But she's kind of the brain on that. So just for all the Penn questions going forward, any news about Penn v. Blinken? What's next? When can we expect an answer from the judge? And I just saw, there was the reply to the opposition to the motion to dismiss that was filed on the 13th, so 2 days ago. And in your experience, Zach, how long from a reply to an opposition to a motion to dismiss can a judge sit on it? When would we maybe expect to see anything from the judge?
Yeah, this is one of those areas where I think, as the other attorneys have said before, it's kind of like up to the judge. I have a case that I just said, yes, we can dismiss this case a month ago, maybe a month and a half ago, and we still don't have an answer on that. And that's not even arguing. That's just us saying, okay, let's dismiss the case. So it really depends on the workload of the judge. It's hard to say when we'll get an answer. But what's next is we will get some sort of decision from the judge, and then we'll move for a summary judgment. I don't have honestly haven't read the reply yet, so I don't have specifics on what the arguments are, but I'm sure it's very much similar to what we're seeing in other cases. You can't sue the Department of State. The Department of State is totally immune from judicial review, which is just not the case. Plaintiffs' claims are all about jumping to the front of the line, which is, again, just not true. Or there is no line. We're trying to get cases to do to the Rio Consulate to do anything. But yeah, so next steps are we'll figure out where the judge stands and move to win the case.
Okay, Marina asks, again, a question for Jennifer, who is unfortunately not here, but good for her. Enjoy yourself, Jennifer. What is the last update in the K1 Egypt lawsuit, and when are you going to submit the summary judgment? So I know that we responded to the motion to dismiss. I don't know if there's been another response to that response to our opposition since then, but I don't expect that there has been.
Yeah, I haven't heard of it being filed, to be honest. That basically just means that we're going to be waiting for, again, kind of like the Penn case, the judge's decision. And then really pretty much as soon as we have that, we'll be filing our motion for summary judgment. A lot of these cases are very similar, so the arguments are going to be similar, and it'll be pretty quick for us to put the summary judgment motion together and get that filed. In the meantime, I think people are being scheduled for interview. I don't have the update sheet in front of me. I can pull that up though. I know it's not the rate we want, but it's at least it's something.
Yeah, and I just checked, and it looks like there wasn't a we opposed the motion to dismiss, and there was no reply to that. So
we're waiting on the reply, and then we're waiting on the judge. That's where we stand there. All right, I guess. Well,
oh, did you have something else to add?
No, I was gonna say
question. Okay, so the general consulate from Rio is leaving his position. Would you think that could have anything, any effect on the Penn v. Blinken case?
I mean, ultimately, as far as the legal claims go, I don't think so. Perhaps we're going to get a more sympathetic general consulate or consul general. I don't remember which word comes first. Who is more willing to push forward K1 cases, and in that case, the effect is going to be huge on actually getting people scheduled. But as far as the legal claims go, having a new person in charge of the Rio consulate's not going to substantively change that.
Yeah. Another question about Penn. I'll skip that. Go to Patrice. She's asking, what happens if no response is received for a writ of mandamus lawsuit?
Yeah, so kind of like if, I mean, this is really in any type of lawsuit. If we were to sue, I don't know, if I was to sue Ryland for defamation because he talks about how poor I speak on Facebook Lives, he never responded, I would get what's called a default judgment against him. The court would say, okay, well, you never responded, so we're going to just say you win, Zach. You're in the right here because Ryland never responded. Same thing here, a little bit more nuanced because it's the government. There's a general disfavor towards default judgments, and you really don't push for them unless there isn't any response at all. With the kind of professional courtesy is to be like, hey, I see you missed your deadline on responding to our complaint or our mandamus action. Maybe you want to get on that. We'll agree to give you a couple of extra days. But let's say that doesn't go anywhere. Then we have say to the judge, here are the things that we've done to try to give them extra time. We're not getting any response from the government. Here's a motion for default judgment, and that just means that we win in that case, and we're able to, push forward as if we won after a summary judgment motion.
Okay. Natasha, again, asking about the Penn case, but also saying that banter is always welcome. So we already gave an update about the Penn case, but I wanted to...
We're trying our best with the banter,
Here's some banter for you right here. Okay. Cal Ab asks, so they adjusted status in the United States. They had consular processing. And then they formed the embassy to close the matter, but they have not gotten a response from the embassy.
Yeah, I mean, generally when somebody goes from consular processing to adjusting their status in the United States, just sending a notification to the National Visa Center if the case is at the National Visa Center or the embassy is sufficient. I mean, if you get scheduled for a consular interview, I mean, you're not going to go. You already have your green card. So it's kind of a courtesy, but I wouldn't be worried about losing your green card or anything like that if the consulate is unresponsive, as it appears they have been.
Okay. And Ronald DaCosta asks if we have any assumptions about the Go case. So I guess any updates. Again, this would be a case that Aaron he's kind of the lead on this one. But Zach, do you have any idea of what could be happening in the Go case right now, or if it's just another wait for the judge?
Yeah, so there's a hearing on Monday. I know everybody's preparing. My assumptions are that Aaron and Chuck are going to do an amazing job. But as far as after that, really haven't touched the Go case at all. My assumptions are going to be that Judge Mehta, because he's really familiar with the issues, is going to, I guess, be very sympathetic to our lawsuit, especially where we're saying, you know, hey, we filed this a month after fiscal year 2021 started, and here's where we're at now. Clearly, you know, the government has not been acting in a good faith way. I also think the Go case is situated differently than the Gomez cases because just because of, I guess, numerous things. Number one being COVID. A big thing that could be argued in Gomez was that consulates are closed, and what are you going to do? You want me to process all of these visas while COVID is ravaging the world? And the judge was sympathetic to that argument. With Go, we're saying, like, hey, consulates have been open this entire fiscal year, and they just are not processing them. So my assumptions there are that the judge is going to be very sympathetic to us, and that because of Aaron and Chuck's incredible oral advocacy skills, we are going to have a terrific result. But again, it remains to be seen how long it'll take before the judge makes a ruling.
Yeah. Andre Stabelsky asks a long one. The House Appropriations Committee approved the fiscal year 2022 Homeland Security Funding Bill, Rep. Meng number 1, that allows unused fiscal year 2020 and 2021 diversity visas, employment visas, and family-based visas to remain available in fiscal year 2022 and beyond until they are used. The amendment was adopted by voice vote. Do we think that it'll pass the Congress? How many votes should it get to become law? And any dates?
Yeah, so my general sense of things moving forward in Congress right now is that they'll pass the House and then they'll get stalled in the Senate. Just the way that the U.S. Senate works, really, unless you have 60 votes in favor of a particular bill, it's not going to go anywhere unless you're able to use this specific process called reconciliation, where the two bills kind of come together, and especially budget reconciliation, where budgets budgets have to be passed, right? So people will add on little pieces of other bills into those budget proposals, and in this reconciliation process where the Senate will pass one version of a bill and the House will pass another one, and then they'll come together to reconcile those and to create kind of a joint congressional bill to be sent to the president to be signed. That's an opportunity for I guess the pro-immigrant members of Congress to add and to push their focus on various immigration issues. So I think that in large part, we're not going to see much in the way of help from Congress until that reconciliation process. As far as dates, to be honest, I don't know when reconciliation is, but that would be when I would expect to hear anything about that. I mean, that's a huge accomplishment already, that it's in front of Congress, and Congress is aware that this issue exists. That, there's going to be these unused visas, and like our employment-based lawsuit that we're getting ready to file, there's going to be some that are going to basically disappear, including diversity visas, and that's not a part of that lawsuit, but that's Go. Yeah, the fact that Congress is aware of it is huge in my mind.
Yeah, I agree. I think it's at least a step in the right direction. And for Natasha Fye asks, for those who aren't familiar with lawsuits, what does it mean to submit a summary judgment? And when and why do you do that? And what happens afterwards?
You want to take that, or you want me to?
Sure. Yeah, so summary judgment is once there are two parties in the plaintiffs and the defendants. In this case, we're the plaintiffs suing the government, the defendants. And if we both agree on all the facts that have happened in the case, so we're saying that they're not issuing our visas, and we're saying that they're doing it because of an improper policy that they're using, and the government agrees, and they're saying, yeah, we're not doing that, and yes, we're depending upon this policy to not issue your visas or schedule your interviews or move forward at all. Yeah, that's right. And what are you going to do about it? Then we can go, once we've issued the complaint and they've read it and responded, they've issued the administrative record, which is the government's version of here's everything related to this case that we're relying on, that they say that we're relying on for all of our decisions and everything that's happened here. This is the administrative record that the judge can look at and see what has gone on. So those are kind of like the facts in the case. Once they do that, then we could move for summary judgment, or the defendants, the government, could move for summary judgment, saying, hey, everything's here, judge. We don't even need to go to trial. We can just have you decide this as a matter of law. And the judge can look at our complaint, look at the defendant's response, the government's response, look at the administrative record, and based off the analysis of the law that we're proposing and the analysis of the law that the defendants are proposing, the judge can pick which side he thinks is correct, and then just issue the judgment right then and there, and the case is over. He'll say either defendants win or plaintiffs win, and that's what summary judgment is. It's just a faster version, without having to go to oral argument, without having to present the case at a court in front of the judge. The judge would read what we've already submitted and decide it that way. And it only happens if one of the parties makes a motion for summary judgment. And I know that has happened in some of the cases. I know that they tried to do it in the Egyptian spouse's case, but at that point they had not produced the administrative record, which is what the judge would need to look at to decide whether or not there has been a reasonable policy or how they've decided to go about adjudicating these visas. I mean, one of the issues that they keep saying is, well, you just want your plaintiffs to be at the front of the line. And we keep saying, what line? What are you talking about? You've provided no evidence of how you are organizing our plaintiffs or people that aren't part of the lawsuit. And, plaintiffs write to me and they say, hey, I know people that got documentarily qualified after me, or they just submitted their visa petition after me and they got scheduled for interview before me and they went through before me. And so that's one of the examples of how is there a line? What way are you deciding to process these? And that's something that would need to be demonstrated in the administrative record I think for summary judgment. A judge might not need to see a line, but at least if they're saying that there's a line, then I think it should be produced as evidence. I hope that answers your question for what summary judgment is. Is there anything that you would maybe add to that, Zach?
Yeah, the way I kind of conceptualize it is that it's a paper trial. So the two requirements are that there's no material facts in dispute, and that's why we have the administrative record. Here is all the facts, and that one party is entitled to judgment as a matter of law. And that's where we say, okay, well, INA 212F does not allow the restriction of visas, or there's been an unreasonable delay for plaintiffs based off of the track factors, they're called. And that's where we say, here's the law, here are the facts, judge based off of the law and the facts. This is the result that should be I suppose reached. There can be oral argument on this, and it's just not a trial, I suppose. You're not going to get a jury. You're not going to have that whole multi-day thing where people stand in front of the jury box and argue what the facts are and how those facts trigger the law. They're saying, these are the facts based off of the administrative record. This is what the law is, and based off of the law, as applied to the facts, here is the result. Very much a trial just on paper. And what happens after is just the judge makes a decision and says, okay, on this legal issue, plaintiffs win. On this legal issue, defendants win, what have you. I mean, even not in the immigration context or the kind of administrative lawsuit context, motions for summary judgment are not not uncommon. What'll happen often is that you'll go through the process of discovery, which is where you're kind of fighting back and forth about what the universe of facts are in your case. And as soon as you kind of know what the facts are, then you'll move for partial summary judgment. You'll say, okay, on this legal issue, plaintiff should win, and the judge will make a decision on that. It's just very much a way to kind of limit legal issues that need to be resolved at trial if it's a case that goes to trial. And for a type of case like this, where we're suing an agency and the facts are just the administrative record, everything is resolved through summary judgment.
Okay. Another long one. So Jim asks, he is in the London mandamus and the Kinsley, he's a Kinsley plaintiff, sorry. And on Monday and Tuesday, some of them got an email saying that their cases had been requested from the NVC. But then in another email today, they replied about getting no priority. So do we think that his case is still being requested as they said it was? Some plaintiffs say SEAC says in transit, most still say at NVC. A plaintiff with NOA 2 April 2021 says in transit. So it shows that they aren't doing it in order of priority. They're all confused.
There's exactly the issue that there's no line. We have, you're seeing exactly that certain cases are being requested, even though, you may have had your NOA 2 in March of 2020 and this person has April of 2021, but there are cases being requested by the consulate before your cases. Just the, I suppose, whole purpose of the lawsuit is to say, hey, this isn't fair. As far as do I think your cases have been requested, I would say probably if the embassy has said, yes, we've requested your case, the online systems may just not have reflected that yet, or it could be that they're just taking some time because of the backlog kind of everywhere. NBC just might not have updated the SEAC yet. No, I think that your case has probably been requested, but you've got prime example of what we're talking about, of this like jumbled no line mess that the government's arguing against.
I think it's just a breakdown of communication, but I do think also as well that they were requested. Otherwise, why would they have sent that email? There just hasn't been an update in the system somewhere. Minna Isik asks, what's next for the Cairo spouses lawsuit? So part of the motion that we submitted, was it last week or maybe 2 weeks ago? So the government was asking, they said, hey, since all the plaintiffs here have been scheduled for an interview in September, we would like to request a motion to stay the proceedings, meaning let's not fight about this right now. Let's see if all the plaintiffs get their visas in September. And if they do, then we have nothing more to fight about. So we can just get rid of this case entirely. And we think that we're happy right now with all of the plaintiffs having their interviews scheduled in September. We would have preferred to have them sooner, and we did ask for that, and they said no. But with the September dates, we were like, okay, sure, let's agree to this motion to stay. We also responded to their motion to dismiss and their motion for summary judgment, but we said we agree to the motion for the motion to stay. And so that's where we're sitting right now. I just saw an email from the U.S. attorney for the case, and it just came in like 10 minutes ago, and he's saying that because that we've all agreed to stay, we're going to hold off on further fighting back on the motion to dismiss. So they're not interested in fighting it right now, and we're happy to stay until September. And that's if the judge grants the motion to stay, which we will just have to wait to see, but both parties are agreeing to it, then we'll just have to wait until you guys all have your your appointments in September, and if something bad happens before then, if all the appointments are canceled, then we're gonna have the fight again. We're gonna start the same, I mean, not start it again, but we're just gonna resume where we left off of saying, what are you doing? This is ridiculous, and we need to have these visas adjudicated now. So that's the Cairo spouses update. Okay, Natasha Fye is back. And she said, now that the government has replied to our response to their motion to dismiss, are we going to submit for summary judgment for the judge to decide, or are we already at the step that we're waiting for him to rule? She's just wondering if there are any additional steps we are waiting on, or if we're waiting for the judge now.
So substantively, there's going to be two rulings from the judge here on the case. The first is based off of this motion to dismiss, and that's what we're waiting on right now. And then once we have a response on that motion to dismiss from the judge, once he's made a decision on that, that's when we're able to move for summary judgment. Right now, we're waiting for the judge to rule on that, and then once that's done, then summary judgment comes pretty much immediately after.
Okay, then we have Camilla Schiss with the last question. When will we have a decision in Kinsley? Why has a stipulation of dismissal of select plaintiffs by all plaintiffs been filed?
Finally, one that I can speak to. I think we are still waiting on a reply to our motion for summary judgment, and that I think the due date's tomorrow for the government to respond. At that point, it's in the judge's hands again to make a decision on whether we win the case or not. That's the summary judgment part of this. As to when, hard to say. Boasberg has been very, Judge Boasberg, if you're watching, I'm very respectful, Your Honor. As far as, he has been very quick in the past, so I'd expect a decision relatively quickly. There's no hard deadline for him to make a decision on the case. As for the stipulation dismissal of select plaintiffs by all plaintiffs, basically, if you've got your visa already and you're flying to the U.S., you're in the U.S. already, you don't really have a claim in the lawsuit anymore. Part of the government's motion to dismiss the case is that, hey, these specific plaintiffs don't have a claim anymore. There's nothing for the judge to rule on. If you already have your visa, there's nothing for the judge to do. Even if the judge says we win, nothing changes for you. So in that case, those people are what's called moot. Their claims are moot. It's a doctrine called justiciability. It's constitutional law that is really horrible to learn in law school. But basically, you have to have a live case to have the judge rule on. Where people have had their visas issued, they no longer have that live case. And so we dismiss those folks. It's a stipulation because the government agrees. The government's like, okay, yeah, they've been issued visas. They really don't have a case in this lawsuit anymore. So we would agree to dismiss them. It's not us asking permission from the judge. It's us saying, hey, both sides of the case agree that these people have had their visas issued and their claims are moot. So would you please dismiss them from the lawsuit? It's filed by all plaintiffs because that's just the box you check when you file on the government system. Otherwise we would be clicking your particular names, and there's 50 of you in there, and it's just it would be unwieldy. So instead, we have an all plaintiffs button that we can click, and we do that. That's I guess the long and short of it.
Yeah, well, that was the last question. Minna says, thanks again for everything. Thank you, Minna. We appreciate you stopping by the Facebook Live to get some updates. That's
right. So hopefully this first one with no Josephs or Halls on went splendidly. Mm-hmm. Nobody's going to watch this, and I'm not going to get an earful about how poorly I did on Facebook Live with no bosses.
Zach, I think it might be a new age.
Anyways, thanks everybody. hopefully got some information that you were looking for, and I hope everybody has a great rest of your week. Monday is the big update after the Go hearing, so tune into the Impact Litigation channel. Then I'm sure there's going to be so much to talk about, and I believe everybody can actually listen into the Go hearing themselves. So yeah. Have a great rest of your week, great rest of your day, and yeah, we'll all talk soon next Thursday at noon Mountain Time.
See
Bye,
ya.
everyone.